attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series detailing testing the waters when conducting an offering using Form S-1. The waiting or pre-effective period is that time frame between the filing date of a registration statement and the effective date. As with all periods in the offering process, communications with potential investors are strictly limited and regulated during this period. Also, as with other offering periods, many exemptions and safe harbors exist to allow for communications during the pre-effective waiting period. Communications under Section 105C of the Jobs Act, which are available in the pre-filing period, are also available during the waiting and pre-effective period. As a reminder, Section 105C allows an emerging growth company to test the waters by engaging in oral or written communications with qualified institutional buyers, also known as QIBs or QIBs, and institutional accredited investors. As always, no sale transaction can be consummated until after the registration statement goes effective. Another allowable communication during this period is under Rule 134, which permits the company to communicate limited factual information about the offering after the registration statement is filed with the SEC. The allowable content of a Rule 134 communication is similar to that of a Rule 135 communication, about which I've already spoken. However, a Rule 135 communication is just a notice of a proposed registered offering, whereas a Rule 134 communication relates to a filed registration statement for a particular offering. A Rule 134 communication may include one or more of the following information: factual information about the legal identity and business location of the company, including name, address, phone number, web address, email address, principal office location, investor relations contact information, country or state of location or organization, and similar information. The title and amount of the securities offered, which can include a designation such as preferred, convertible, or secured. A brief statement of the general type of business of the company. The price of the security, if known. A brief description of the intended use of proceeds. The types of underwriting, such as self, firm commitment, or best efforts. Names of underwriters and other offering participants. Schedule and timing of the offering, including roadshow dates, times, and locations. Legal opinions as to specified tax treatment. The names of selling security holders, if any. Names of exchanges or other markets where the security currently trades, and ticker symbol, if any. The communications must contain the prescribed legend, be preceded or accompanied by a Section 10 prospectus, and state where the statutory prospectus can be obtained, which is usually on the Edgar database. The required legend is as follows. A registration statement relating to these securities has been filed with the Securities and Exchange Commission, but has not yet become effective. These securities may not be sold, nor may offers to buy be accepted prior to the time the registration statement becomes effective. Subject to limited exceptions, the following may also be included with the legend. No offer to buy the securities can be accepted, and no part of the purchase price can be received until the registration statement has become effective, and any such offer may be withdrawn or revoked without obligation or commitment of any kind at any time prior to notice of its acceptance given after the effective date. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.